We're happy to hear argument in our first case, Reeves versus Meddings. Mr. Oxley?
Oxley, Your Honor.
Thank you.
Judge Motz, before we begin, I think it's appropriate to note today that this will be Judge Motz's last panel as an active judge.
Yes.
And I know I speak for Judge Harrison saying what a pleasure it's been, and we look forward to having you back often as a senior.
Thank you. Go ahead with
Thank you, Your Honor. May it please the court, my name is Perry Oxley, and I represent Howard Meddings in this case. I'm arguing a case today of a denial of a motion for summary judgment that my client brought based on qualified immunity. And Howard Meddings was, for the operative time period in this case, the parts supervisor at the Wayne County Bus Garage in Wayne, West Virginia. James Lee Reeves, who is now deceased, and Katrina Reeves also worked for the Wayne County Board of Education. Lee Reeves was in charge of that bus unit, and Katrina Reeves drove a bus. In this instance, Lee Reeves and Katrina Reeves brought a claim for civil conspiracy against Howard Meddings under 42 U.S.C. 1983, and they alleged violations of the First, Fourth, and 14th Amendments in that regard. The operative issue in this case is the misapplication of the standard for qualified immunity by the district court judge, and that's why we're appealing here today. The gist of this case, and we'll get into the meat of it, but the gist is that the federal standard is a two-pronged test and does not require a showing that there was not intentional, fraudulent, or malicious conduct. The district court in this case superimposed that requirement in this context for the claims for violations of 42 U.S.C. 1983 and those constitutional amendments.
If we agree with you that the district court applied the wrong standard on federal qualified immunity, do we just send it back to apply the correct standard?
Your Honor, I think that would be the correct ruling. I think there is an argument that...
correct ruling? Could we do that ourselves? It's a question of law, right?
Correct, it is. And I think that's the standard that you're getting at. Your Honor, is de novo here. And there's...
Well, there are no facts for the district court to find, right?
Well, there's the record.
With respect to that. So we would be just as able to do it as the district court to apply the correct standard.
That's correct, Your Honor. And in that regard, I think this court could reverse it and remand and ask for an entry or make an entry for summary judgment in favor of Mr. Meddings based on qualified immunity.
But if we're just applying the law to the facts and the judge made a number of factual findings, if that suffices to show qualified immunity notwithstanding the malice factor, we could find for the other party, couldn't we?
Well, Your Honor, I think that in this de novo standard that we're dealing with, you can look at the record.
No, we can't, counsel. Not on appeal and in this interlocutory posture. We have to take the record as the district court saw it. We don't have jurisdiction to review the district court's assessment of the record, the degree to which the district court found disputed facts. We have to accept all of that in this posture.
Well, Your Honor, I think that you can accept the facts here and look at and there's no finding by the district court one way or the other concerning the operative nature of this issue. And if we go through the facts of this case, none of the search warrants in this case had any basis concerning Howard Meddings' comments.
Can I ask you a question? So the district court found that a reasonable jury could find that your client actively participated in this criminal investigation. And again, we don't have jurisdiction to review whether or not the district court was right or wrong. The district court found that that is a disputed question of fact. And so the first question on federal qualified immunity, before you even get to clearly established law, is was the officer acting within the scope of his authority under state law? That's the threshold inquiry under federal qualified immunity. And I guess I need you to explain to me how conducting a criminal investigation was within the scope of your client's state law authority as a parts supervisor.
It's his job to maintain the part. So he did not do the investigation, Your Honor. He
Well, but the
cooperated with.
the district court said that that was a disputed question of fact, whether he simply cooperated or whether he actively participated.
So we have to take the facts the way the district court found them for purposes of our analysis here.
Well, he participated, I'm sorry, Your Honor.
Go ahead.
In this case, his role, and I think the way the district court found the facts, was that his role was to assist in the determining whether or not the parts were stolen. That was his role in participating. But none of the information that derived from that led to a search warrant being issued. None of those facts and none of those findings.
Not a finding the district court made. The findings of fact, as I understand the record given by the district court, are disputed. There's facts on either side. And if that's the case in this realm of interlocutory appeal for qualified immunity, doesn't that deprive us of jurisdiction? I mean, there are facts still to be found.
I think, Your Honor, that it deprives you of jurisdiction to the extent that you have to rely upon the findings of the court at this point. However, the court applied the wrong standard. The court did not apply the Evans versus Chalmers case, which requires some degree of causation.
Counsel, can I just, so the district court found that your client was an active participant in this investigation, that he was texting and meeting with the deputy, that he obtained, or it was at least a disputed issue of fact for a jury, that he obtained pictures and texts and records from the seized cell phone, that he used those to encourage other employees either not to participate in the investigation or, in fact, to give false information about Mr. Reeves. I don't see how any of that was within the scope of your client's discretionary authority.
I think that was his job, Your Honor.
His job was to participate in criminal investigations?
His job was to maintain the parts for the board.
The district court found that there is a dispute as to whether he did far more than that here.
I understand, Your Honor, but here's what I think is missing from the analysis from the district court judge. It's the wrong standard.
I think you're right about that. I don't know that anybody disputes that it's the wrong standard. The question is, how far do you get with that right now?
Well, my point is it's the wrong standard, and it completely ignores the but-for test. Everything that you said, Your Honor, the but-for test in this case under the Evans versus Chalmers case, that's 703 Fed 3rd 636 2012 case. In that case, the court found that in order for there has to be some material violation. So, for instance, you can have a violation, you could have participation, for instance, Your Honor, but if the warrants would have been issued in the absence of whatever participation there was, the dispute of fact about whether or not he participated or how much, these warrants, if this court remands this decision and asks the court to examine whether or not, in fact, this could have been caused by this participation, then I think that that's the proper finding here. None of the search warrants, not one of them, were based on information provided by Howard Meddings. It's very clear. In this case, what happened was Lee Reeves, in this case, and the record shows this. I know you got to go by what the district court shows you, but the bottom line is, in this case,
The charge of this case, I think, was conspiracy. Is that right?
No, conspiracy for 1983 came under 14, yeah. First, Fourth, and 14th Amendment.
In a conspiracy, you have a different set of elements and facts than you would in the underlying crime. I mean, they're separate. You don't have to prove the underlying crime in order to prove the conspiracy, correct?
I think to prove the full claim, I think.
There may have to be overt acts and that sort of thing, but this is a conspiracy. It's not the underlying crime. So there are going to be other actions that may not be dispositive for the underlying crime that would be relevant, though, with a conspiracy charge.
I think the law is pretty clear, Your Honor, that for a conspiracy claim to attach, there would have to be a showing that there was a constitutional violation under 14 U.S.C. 1983. And in that regard, Your Honor, the operative documents in this case weren't analyzed.
Can I ask you a question about that? Because the state court, when the embezzlement claim was dismissed, right, the state court, like this is not a case where there's no there there. The state court did find that the deputy in this case gave false information. And although the deputy said, yes, it was false, that was a mistake. The state court found no, given the quantity of the misstatements, we're going to assume that at a minimum it was reckless, and found that those statements were material. And so there's someone in this conspiracy was doing something wrong, right?
Well, Your Honor, if you get to the basis of this, what happened here, and bear with me in answering this question, what happened here is that Lee Reeves voluntarily asked the investigating deputy to come out to his personal residence and examine this barn area, which he did, and he took pictures of all this stuff. Lee Reeves confessed that this was material that was from the Wayne County Board of Education, and then he allowed, then he went back and examined that material and compared it to he said he got it at auction and compared it to the auction. That's how the warrants were.
I'm sorry, I think I was inartfully trying to ask a different question, sort of picking up on what Judge Agee is saying. This is a conspiracy count. If, for instance, the deputy in this case violated Mr. Reeves's clearly established rights, and based on the state court opinion, that seems plausible, and your client helped him do that, isn't that enough? I mean,
No.
you can't isolate out your client's activities and ask whether only those activities violated clearly established rights.
And so, Your Honor, I would go to Massey versus Ojanita, 759 Fed 3rd, 343. And the issue is whether or not, in that context, those constitutional violations were material. And if, in fact, all these warrants would have issued anyway, regardless of my client's participation, then that doesn't matter. It's very important to make this one point. In the statement, the 10-page single-space statement from Deputy Sowards to the Wayne County Magistrate and his subsequent testimony, there are 3 witnesses who testified that they observed Lee Reeves stealing material. Ronald Chick Chafin, Nathan Belcher, Terry Ramsey, all were referenced in that document as having witnessed it themselves. And so my point is, the warrants, the preliminary hearing, the grand jury, all that would have gone down without Howard Medding's participation because there were eyewitnesses to the conduct. And that's my point. It's not material. My client's participation wasn't material. And so as a result, I don't think it's a constitutional violation. That's our position in the case. I think it's pretty clear that they have to establish that in order to get to that point. And so the question here is, what's the material violation? And there is none, because all of those documents would have, and we provided this to the district court, but the district court, as Justice Moults pointed out, applied the wrong standard.
Do you think that might be because that's all you argued in your summary judgment motions? I mean, I agree it doesn't look like the district court thoroughly analyzed a federal immunity claim, but I did look at your summary judgment briefing, and you only argued the state claim. I mean, you cite the federal standard, but the only 2 arguments you make are under the 2 prongs of the state immunity standard, and then in your reply brief, literally the only thing you argue is we're entitled to immunity under West Virginia law. So look, I agree with you that there's not clear focus on the federal standard in this case. But I'm a little uncomfortable with suggesting that, wow, the district court must have been entirely out to lunch. The district court just tracked your briefs.
Your Honor, we filed a supplemental brief also, and that supplemental brief clearly sets forth the standard and the 2 new Supreme Court justices and the 2-prong test. And so, and I argued it too, Your Honor.
Suppose that the court should hold, yes, you're right, applied the wrong standard, but then we have to send it back for all of the reasons that my colleagues have said, don't we?
Your Honor, yes, I agree.
You have to apply the correct standard to the facts here.
Correct, Your Honor, and I think that the correct standard, with the understanding...
I understand what you think, but
yeah,
the district judge is going to decide that, right?
I would agree, Your Honor. So, Your Honor, we argue, Your Honor, this case should be reversed and remanded, and that with instructions that the court make findings associated with not only that they apply the two-prong test and find a constitutional breach in this case so that qualified immunity can be determined, and that fact finding be made by the court. Thanks.
Mr. Glazer?
Thank you, Your Honor. Good morning. May it please this court, Justice Agee, Justice Motz, Justice Harris, Mr. Oxley. This is a special appeal. The standard of review here, as this court has acknowledged during counsel's opening presentation, is limited. It's limited to one narrow legal question. And this is from the Livingston versus Cahigis, I hope I'm pronouncing that right, case from 803 Fed App PPX 673-2020. If we take the facts as the district court gives them to us, and we view those facts in the light most favorable to the plaintiff, is the defendant officer still entitled to qualified immunity? We have over 1,000 pages of records in this case, and as your honors have acknowledged, Judge Chambers looked at the records, he looked at the depositions, he looked at the documents, and applying the rules, he found...
Well, what about the standard?
Let me go to that. Yes, Your Honor. I want to go directly to that, the saucier standard. So, I will tell you right now, I agree with Justice Harris, which he said perhaps it wasn't as clear as it should have been in the final order as far as the federal elements. Our position throughout this case has been that the judge did consider the federal standard for qualified immunity, going back to the motion to dismiss, the order on that, and I want to address that.
Well, when the district judge says both qualified immunity, the federal standard, and statutory immunity, the state standard, can be overcome by a showing of malicious conduct, is that correct or incorrect?
I would say that that does not reflect, is not accurate. I would say that it is an overgeneralization. There can be times when you can have conduct in this case that would not allow for state immunity and federal immunity. And let me explain how that can be, how you can have that, but it's not mutually exclusive. The standard is, one, is there a federal statutory or constitutional right that's established? Prong one. In this case, the Fourth Amendment, that's pretty clear. That's the first standard.
Counsel, can I just cut you? Because that's actually not the first question. The first threshold question is the person acting within the scope of their discretionary authority? If they are, then we ask, did they violate a constitutional right? Was it clearly established? I don't think you really briefed that first prong.
That's correct, Your Honor. I apologize for that. In this case, I think that Mr. Meddings was acting within his authority.
Well, what about the malice factor, though? I mean, the district judge seems to...
I'm sorry, what?
As I read it, the district judge is saying that malice, in effect, is an additional qualification, an additional element.
Malice...
An affirmative defense, more or less, to qualified immunity, which I thought the Supreme Court tossed out some time ago.
Malice, as far as the Fourth Amendment cases are concerned, when an officer acts with deliberate intent, that could be enough. But in this case, I believe we satisfied the elements to show there's not qualified immunity.
Right, but the officer could act with deliberate intent and bad faith, but the right may not be clearly established.
Correct. Correct. As far as Meddings is concerned, it's...
Counsel, you're not seriously conceding, are
No,
you?
no, Your Honor. I was talking about when Meddings was...
Can you let me just finish my question?
Yes, I
want to make
apologize.
sure we understand each other.
Yes.
You're not seriously conceding, are you, that Mr. Meddings, if in fact he was actively participating in a criminal investigation, was acting within the scope of his state law discretionary authority?
No, Your
Are
Honor.
you? Okay,
No,
thank
Your
you.
Honor. No, and I apologize. What I meant was he was working there, but the bottom line is he went beyond his authority when he does what he does in this case. And I want to address the standard that you've asked me about. The judge clearly articulated that standard in the motion to dismiss, and he said, here it is. You've got to show that, you've got to show these two prongs under Saucier. And then he said at this time it presents a plausible claim that Mr. Medding's actions would not allow him qualified immunity. He said that in the motion denying the motion to dismiss. He said that in his order denying the motion to dismiss. So when Mr. Meddings renews it at the summary judgment stage, we have the law of the case there. The judge has said the pleading itself satisfies the pleading, and we're not going to kick this out on qualified immunity. Then after we looked at the evidence and the judge looked at the evidence, he says, okay, I think that there's a jury question here, and I'm going to let the jury decide this. That's why we're here. And the defense, the appellant, is arguing the facts here. That is 90% of their brief is they're arguing that the judge got the facts wrong, and they're arguing facts that again, we have to take them as the judge found them below.
May I ask a question? If we're trying to figure out whether a right is clearly established for qualified immunity purposes, we have to know what right we're talking about. What is your sort of theory of, what is your constitutional cause of action here? What constitutional right was violated here?
A couple. The Fourth Amendment right, protecting my client's rights to be free from illegal search and seizure and arrest without probable cause. That's the first one. It's our theory, as the evidence reflected below, that Howard Meddings had an agenda against our client, the late Lee Reeves.
I do understand sort of like your factual allegations, but so is this like a malicious prosecution theory under the Fourth Amendment? Is that what we're talking about?
Essentially it is, yes. It brought us in 1983. That's exactly what it is. And here's the thing, Your Honor. We adduced sufficient evidence below to show that Meddings had a motive opportunity to go after Mr. Reeves and Mrs. Reeves, his wife, to get back at Mr. Reeves, who had gotten a job that he wanted. And we developed that evidence, and we showed that Mr. Meddings had a relation with Deputy Sowards and that they conspired to have our clients charged, arrested, and to have their Fourth Amendment rights violated. And it's our position that as a person, a reasonable person would know that telling deliberate lies to law enforcement with the intent to get them arrested would violate a person's Fourth Amendment rights. And as far as the case law on that, I acknowledge that the case law is sparse. We don't have a specific case on point. And I know appellant is correct on you've got to have the general, you've got to have the right established. So the question, I guess, is did we show that? And we did find a case from the 11th Circuit, the Buckner case, where we had an official who provided, false information. And the court said, there's no qualified immunity for that. When you provide false information to law enforcement, you don't get qualified immunity for that.
Does it matter that this is a conspiracy case? I mean, how do we frame the qualified immunity question in light of the fact that this is a conspiracy charge? It's not a standalone malicious prosecution claim against Mr. Meddings. So how do we think about it as a conspiracy claim?
I would submit that this providing false information itself, whether it's individual or other people, is legitimate and sufficient to allow the conspiracy case to go. In other words, if you provide false information in an investigation, it's sufficient to infer that it could be part of a conspiracy if you have that evidence available. And we have that evidence here. In other words, we have the evidence here. I don't think you could...
Is the question, do we ask whether what Mr. Meddings did violated a clearly established right, or whether this was a conspiracy to violate a clearly established right and he participated in the conspiracy? I guess that's what I'm asking. Do we isolate Mr. Meddings' conduct, or do we look at what the conspiracy did as a whole?
I think you look at the whole conspiracy. I think you look at the whole event chain to determine whether or not it occurred, because that's what we pled here, and I think that's the way you look at this case.
There is no standalone malicious prosecution claim against Mr. Meddings, right?
Correct. Technically, that's correct, Your Honor. Yes. I also want to mention that the search, and I realize we're not here to review facts, but he did participate in the search. There are other facts I could get into, but the bottom line is the judge looked at these facts and determined again that Mr. Meddings, did not have developed a sufficient record to show that he benefited from that defense. Bottom line is the appellant wants to change the facts. He wants this court to revise the facts. I would like to be taller like my co-counsel, Mr. Sod and Mr. Anderson here. I can't have it. And the standard is You've got to look at the facts as the court gives them to you. Judge Chambers stated a jury could infer from the record that appellant acted maliciously and intended his false accusations to lead to false criminal charges, depriving the Reeves of their constitutional rights, and that he knew his actions would result in violations of the Reeves' rights. And we submit that that is sufficient to remove qualified immunity from Mr. Meddings here.
Well, Counsel, you recognize, don't you, that, as your colleagues on the other side keep telling us, that federal qualified immunity does not require any malicious act.
I understand that.
That you don't, that doesn't disqualify you from qualified immunity under federal law.
We're saying,
So that was error, right? Your claim may go back because you have state law claims and because you may, under the correct standard, prevail under federal law. But it was error to say that this malice somehow was part of the federal qualified immunity standard, right?
yes, Your Honor, and I think, but as I said before, under the standard, each same set of facts satisfies the federal and the state standard here. Again, you could have a case where you don't have a...
Good. But he didn't apply that standard, right?
Yes. So we're saying here that actions of Meddings, though, that he would know as a reasonable person that that would deprive my clients of their Fourth Amendment rights. That's what we're saying here, that he knew, and a reasonable person would know. And that if a jury gets this set of facts, a jury could well conclude that he doesn't, his mindset and his actions were sufficient to deprive him of that defense. That's what we're saying here. In other words, there's sufficient evidence for him not to receive the qualified immunity. So as far as the standard is concerned, I will tell you, and I acknowledge the court's arguments, the drafting of that final order on summary judgment should have been clearer. I don't believe it was very clear on that. And I think that the court should have been a little more clear in the way it drafted that order. But as far as where we get with that, when you look at the motion to dismiss and the order on the motion to dismiss, the court did go through the elements on that. And when you look at that and the law of the case and the record, I believe that the court did reach the right result here applying the qualified immunity analysis.
Can I ask you just, it has no particular bearing on this qualified immunity question, but what's going on with the rest of this case? We just have the motion for summary judgment of one defendant now. What's going on with the rest of the case?
Yes, Your Honor. Mr. Reeves passed away last year. What happened is ultimately the state court judge dismissed the criminal charges against Mr. Reeves. Everything's been dismissed.
I know about that part, yeah, but what about the other defendants in your claim?
We're awaiting trial. No, the other defendant in this case, I believe Deputy Sowers did not file an appeal, so we're still awaiting trial, and I apologize.
No, I wasn't that clear, but so Deputy, there's no qualified immunity for Deputy Sowers.
Yes, that's correct. That's correct. And those are the only two defendants originally. I know you've read the brief, so I won't belabor the point.
I thought there were other defendants.
There were. The Board of Education, the Wayne County Board of Education was dismissed. Okay. And we did not appeal from that, but they were completely dismissed from this case. We brought similar actions against the superintendent of schools in the Wayne County, but they were dismissed, and that case has been resolved. They will not be a party at trial. They may have witnesses, but they're not a party at trial.
And you mentioned that one of your clients had died. Do his claims continue after death?
It's our position that they do. We've briefed that before the district court, and it's our position that they do survive his death. But the party...
You didn't brief it in this case.
No.
He hadn't died at that point.
He had died, but
in the record that comes up to us,
yes.
At that point, he still had not died, right?
He had died, Your Honor, but I believe by the time the record got to you, I think that the briefing on the decedent happened after the appeal process had been filed in this case.
And what's going on with that issue? So it was briefed before the district court, but the district court hasn't ruled on the survivability?
That's correct. The district court is awaiting Your Honor's decision in this matter.
So who's the proper plaintiff in this case?
We right now for Mr. Reeves' case, we've brought the estate in. We've added the estate as a party for Mr. Reeves.
Well, do we have anything that shows that?
I don't know that you do, Your Honor.
Well, you would be the source of it. You would know.
Yeah, no, the
Do
answer is
we
no.
have the proper parties before the court now?
I believe that we filed it as Mrs. Reeves as the executrix of his estate. I believe we did. And
I mean, is that in the district court or is that in the Fourth Circuit? Or
at
both?
the district court, we did that at the district court.
So let's, separately, let's just assume for purposes of argument, the district court erred in applying the federal qualified immunity standard. There's still a state statutory immunity element in this case, is that right?
That's correct. On the state claims that if you can show deliberate conduct, then you don't get the state immunity.
All right, so let's just assume that we decide that the federal qualified immunity has to go back. What happens with the state statutory immunity?
We have the common law claims at that point, and I believe at that point that state law claims should proceed against Mr. Meddings.
Well, your only appeal is federal qualified immunity. That gives you a right to an interlocutory, or it gives them a right to an interlocutory appeal. That's the only issue that's in front of us. Isn't it?
Correct.
Is that right, that you can't, there's no interlocutory appeal on the denial of state qualified immunity in this case?
That's correct.
How come?
Because
The parties have briefed it.
Right, why do you think that's not, isn't the rule that if it's, we can hear those claims on an interlocutory basis so long as under state law, the immunity is an immunity from standing trial and not just an immunity from liability?
that's correct. That's
Okay.
correct.
So is it your position that the state law immunity here is only an immunity from liability and that's why we don't have jurisdiction over them?
No, it's my position that if you send this back, that the state law claims that the judge decided that appropriately under the state law immunity. In other words, if I understood Justice Agee's question correctly, it was if you send this back, what happens with the state law claims?
No.
No.
Well,
We want to know what we have before us, what we have jurisdiction over. We know we have jurisdiction over a denial of federal qualified immunity or grant thereof.
Right.
What about the state immunity?
You have jurisdiction over that as well,
Why is that?
because it's part of the appeal. Everything's been brought up with the appeal.
But it's interlocutory appeal.
Right.
That means not everything is before us, right?
Correct.
So when you say everything's on appeal, that is not an answer to me to why.
what's your authority that we can decide the non-federal issue on the interlocutory appeal?
I honestly do not have authority on that.
I guess you didn't bring the appeal, so it's not up to you, but do you have a position on whether we have jurisdiction at all, sort of at the threshold, to hear any kind of a challenge to these state law immunity claims? I actually take your brief to be arguing we don't have jurisdiction, we should dismiss the appeal as to those claims because that appeal is based entirely on an argument about the state of the record, and we don't have jurisdiction to consider that.
Correct, and that's my original position, and again, I apologize to the court for not having the preparation on the other issue, but that is my position.
I guess if we're dismissing anyway for a lack of jurisdiction, it doesn't much, we can dismiss on any jurisdictional ground without reaching the others, so, okay.
So, in conclusion, basically we believe that Judge Chambers made the right decision when applying the record, and that we would ask that the judges affirm his decision. Thank you.
Your Honor, rebuttal. I want to make a couple of quick points. One with respect to Katrina Reeves. Katrina Reeves, there are no allegations of any misconduct by my client towards Katrina Reeves in any way, shape, or form in this case.
Well, the district court found otherwise, and again, we don't have jurisdiction to consider that.
Well, there's an allegation of a 1983 claim, I mean, the civil conspiracy for 1983 was brought also by Katrina Reeves. And the allegation of malicious conduct, the finding was based on malice without any specific finding of even a constitutional violation against her. There's not even any evidence in the record with respect to the federal component of this case for the constitutional violations that there were any misconduct. In fact, by Katrina Reeves' own admission, there weren't any. And so,
Well, again, you know, this is a conspiracy, right? It's not that there have to be specific acts against her, but there's an overarching conspiracy that's alleged, as I understand it, that affected both individuals.
but Your Honor, with respect to qualified immunity in this context, and we have to apply the two-pronged test, we cannot identify a clear violation of a constitutional right with respect to Katrina Reeves when there's no conduct in this case that is alleged to be nefarious with respect to Katrina Reeves. In fact, she testified herself that she'd never known any conduct that was adverse from Mr. Meddings herself. And Your Honor, I want to address an issue that Justice Harris brought up earlier with respect to the role of my client in his participation in this investigation. And I want to make the point that the record, and I think it's undisputed in the record, is that the superintendent of Wayne County Schools asked that my client participate in the investigation with Deputy Sowards. It's important to note that in addition to the Wayne County Board of Education and Deputy Sowards, that the Wayne County Superintendent of Schools, Todd Alexander, was a party upon whom summary judgment was granted in this case, and that he made a request that my client, his employee, engage and assist Deputy Sowards in the investigation. In particular part, he questioned Mr. Reeves himself, the superintendent of schools did, and then asked for his participation on an ongoing basis. I also want to make this point. This case is replete with violations of the requirement that the alleged violations be specific and not broad. We have been talking about a variety of different things. The only allegation argued at the hearing below is that my client made assertions that there was a tire scam going on.
Counsel, I'm sorry, I apologize for interrupting, but I see that you're getting short of time, and I was hoping you could address the question of jurisdiction over whether we have jurisdiction to hear the appeal from the denial of state statutory immunity in this case.
Your Honor, it would be my position that the court has the authority to address the qualified immunity issue in this context, and that if, from a federal perspective, and that...
I understand we definitely have jurisdiction over the denial of federal qualified immunity, but you have also purported to appeal the denial of state court immunity in an interlocutory posture, and I wanted to give you a chance to explain why we have jurisdiction to hear that part of your appeal.
Your Honor, I think that was a broader, our argument with respect to your jurisdiction in that context deals with the application of qualified immunity and the fact that the decision by the court in that context with the same general issue covered that, again, and forgive me for this, for going the long way around this, but the malice analysis in this case overrode any factual findings in this case pertaining to a specific constitutional violation. As a result of that analysis didn't take place even with respect to the state court claims. Your Honor, I think that to put it in...
It's wrong. What we're trying to do is decide whether we have jurisdiction.
Yeah, I understand. And our argument would be that you do, based on the general assertion that analyzing the qualified immunity issue with material facts, with the material facts that can be established based on the record that are undisputed, would allow for a finding that it applies to the state court claims. I understand, Your Honor, that's a stretch and an ask for extension of the law, and I can't cite your case right now. That's my argument. Real quick, if I could follow up just briefly on a couple of things. The appellee cited to the Buckner case, which is an 11th Circuit, what he called 11th Circuit decision. That's a Middle Tennessee, Georgia case. It is not a case that identifies or puts anyone on notice of a notice of that conduct would be a violation of the Constitution in that context. I also want to point out that case, in that case was a post-trial motion case, and that in that Buckner case, the jury had already found that there was a causal nexus between the conduct and of the person and the constitutional, or the damages in the case, the constitutional violation. That's not been done here. In fact, that analysis is exactly the part of the analysis that needs to be done when the case goes back, because there's no findings of fact after the assertion of malice. I want to go back to, and this is the point I was trying to make earlier, with respect to the material must be operative and material. Throughout the day, we've said we have to stick to the circuit court's findings, but I think the case law allows the court some degree of discretion as it pertains to undisputed facts. I want to make the point that it's our contention that the warrants are uncontested. The findings are in the record. The material considered by the magistrates are in the record. And this court has found in the past that it acts as an intervening, superseding cause when a magistrate makes a decision in this context. Also, every single one of these operative documents would, every single one of these acts, the searches, the seizures, the indictment, would have occurred without my client's participation. And again, specific, not broad, specific, the allegations that have come upon us from the appellees throughout the course of this time period have all pertained to the argument, an allegation that my client said to other people, Lee Reeves is running a tire scam. And that's what it is. That's what the allegation is. When that was pressed, and I think that the hearing at the circuit court level suggests this, when this was pressed at the lower level, their answer was that Lee Reeves said, that Howard Medding said Lee Reeves was running a tire scam. And that's not a constitutional violation, Your Honor. And it was completely inoperative. That's all I have.
Well, thank you very much for your arguments. I think that we will go directly to the next case.
Judge Motz, before we leave that, could I suggest that I don't find anything in either brief on the jurisdiction of the court over the state interlocutory appeal? Could we ask the parties to send us a brief 28J letter telling us why we do or do not have jurisdiction over the state statutory immunity?
That's fine, Your Honor.
I'm more than happy to do that, Your Honor.
You understand what you're to do?
Yes.
Short, a letter, maybe with a citation, you know? Okay. Thank you.
Thank you.
Thank you.
And within a week.
Thank you, Your Honor.
Thank you.
West Virginia colleagues. We're happy to hear arguments United States versus Velasquez whenever the lawyers are ready. Counsel, we're ready when you are.
Thank you, Your Honor. May it please the court, I'm Ann Hayes. I represent the appellant Anil Velasquez on this appeal. I plan this morning to focus chiefly on the challenge to the district court's denial of the motion to dismiss the case on speedy trial grounds, and I also intend, if time permits, to address the argument regarding supervised release conditions. As to the additional argument regarding sentencing, I wish to rest on my brief. Mr. Velasquez entered a not guilty plea to two counts on July 22nd, 2019. Assuming that no speedy trial days had elapsed prior to that time, countable time, the court had 70 days to bring the case to trial under this non-excludable days. So assuming that no excludable days occurred, the case should have been brought to trial, should have begun by September 30th, 2019. But a scheduling order didn't issue until after that time had expired. And the scheduling order was issued on November 7, 2019, and set the trial for months later on February 25, 2020. So the speedy trial clock ran uninterrupted from the July 22 date until February 5, 2020, when defense counsel filed a motion to withdraw from the case due to a conflict. Against this backdrop, the defendant personally filed a demand for speedy trial with the court, and then his attorney filed a motion to dismiss the indictment based on speedy trial grounds. The district court erred in three regards when it denied the motion to dismiss based on its characterization, its reliance on the statutory provision regarding ends of justice continuances. First of all, I want to note that the language concerning ends of justice continuances is an uneven fit in this case because there was no continuance. At the time these events started, there was no trial date. There was nothing to continue. So there was a delay, but it technically was not a continuance of an existing trial date. Because the last time the judge set a trial date was immediately after the indictment. After that time, several times the arraignment was continued, but there was never another trial date set until the case was very old. And 7 months after the not guilty pleas, 6.5 months after the not guilty pleas to counts 1 and 4 of the indictment. There were three flaws in the judge's reasoning in this case. First, the statutory requirement for contemporaneous findings was not met. Second, there is no record support for a contemporaneous finding that the delays that the judge approved were warranted to provide counsel time for trial preparation. And third, the open-ended nature of the delay was unreasonable.
Counsel, how much are you relying on the open-ended nature of the delay? Would it make a difference if the district court had said in that minute order, in 180 days, we'll have trial?
No, Your Honor, because there was no basis. The other two flaws in themselves render the judge's ruling erroneous.
So your argument about open-ended delays is one we really don't have to reach.
You don't have to.
You would like us to, but
I would like you to, but it certainly factors into the reasonableness or the inaccuracy regarding the other flaws.
You're saying we don't have to decide whether an open-ended continuance is ever okay, but you think we should look at the open-ended nature of it it should factor, it is sort of a factor to consider.
Yes, Your Honor. So that...
Any court said that?
Sorry? I'm sorry, Your Honor?
Has any court said that because most of the circuits, as I understand it, don't take a position that open-ended continuances per se are invalid under the statute. What I'm asking is, do any of those circuits say, well, nonetheless, we're going to continue with it, we're going to look at it as a factor in the delay? I mean, if you've got a delay that exceeds the time period, what difference does it make?
The cases that address, and I hope I answer your question accurately, the cases that direct whether an open-ended delay can be granted really talk specifically about that, not as, because in those cases where they've talked about open-ended delays, continuances, and approved them, there has been a reason stated for the delay. There's been a reasonableness requirement imposed. So that ended up being the primary problem in those cases, was the open-ended nature of the delay, rather than whether the judge made findings or whether the judge, those findings were supported, Your Honor.
So why don't we look at the time period here, say starting with the July 22nd minute order, and tell us why in any given time period the trial court failed to comply with the statute.
Certainly, Your Honor.
If you do that, then the open-ended continuance part's really not relevant.
That's correct, Your Honor. So let me get started. On July 22nd at the hearing, the judge simply at the end of the arraignment process said, do y'all want to talk about trial dates? They said, well, we'll get back to you on that, Your Honor. Is that all right? Yes, that's all right. Nobody acknowledged that there might be any delay that would impact the Speedy Trial Act. Nobody mentioned speedy trial. Then in the minute order, which incidentally, a minute entry should reflect what happens in open court in the courtroom, because nobody mentioned speedy trial computations, any exclusion. That minute order should be a nullity. Plus, there's the fact that as a practical matter, minute entries generally are made by clerks, not the court. It's really hard to know what the genesis was for that, and whether it may be just that clerks are told if there's a delay, you always need to put on that docket sheet that it's excluded from the Speedy Trial Act. So I'm not sure I don't think that minute entry gets us anywhere.
So, I mean, are you arguing that the minute entries are simply invalid evidence? I don't think any court's ever said that in this context, have they?
I am not familiar with courts that rely simply on minute entries to determine speedy trial findings, Your Honor. And I'm not aware of any provision that allows, except in those cases where the docket sheet specifically says this is an order on the docket sheet. If it's a minute entry that reflects what happens in court, it should reflect what happens in court, and that's not what happened in this case. Moving on to the findings at the November 7 order, the judge said, the court finds that the ends of justice served by granting this extension outweigh the best interests of the public and the defendant in speedy trial. It doesn't identify what dates it might be talking about, how many days are excluded. It's not talking about a continuance. But most importantly, it does not explain what the justification is for the continuance or for any balancing act. And the statute, by its terms, require not only that the judge say that the continuance outweighs the best interest, the ends of justice outweigh the interests in a speedy trial, that it also must set out its reasons for finding that the ends of justice served outweigh the interests of the...
Sorry, can you just, I lost track for a second.
Yes.
Just to clarify, we're talking now about the order that issued on November 7th?
That's correct, Your Honor.
Okay, but I have a question. If we think, hypothetically it were the case that we couldn't be confident that there was a contemporaneous end of justice finding back on July 22nd, it wouldn't really matter whether the November 5th order was sufficient or not, right? Because the first 188 days by themselves,
That's absolutely correct, Your
so
Honor.
we don't-
So you just, it just accumulates, but you're right. If we don't have an adequate finding on July 22, and we don't,
okay, because you have, it seems to me you're raising sort of two very different arguments. One is there was nothing on July 22nd, and then you have a different argument about November 7th about kind of generic ends of justice findings. There was a finding, but it was kind of generic.
but it wasn't good enough.
But we don't have to reach that question if hypothetically we agreed on the first question.
That's correct, Your Honor. And I'm going to jump now to the order on May 20, the oral order that the judge made. Again,
Now that you're there, and to
Yes, Your
follow
Honor.
Judge Harris's question, let's say everything is as it is until you get to May the 20th. And at the motion to dismiss hearing, the district judge says, what he says in the record, on July 22nd, I excluded the time under the Speedy Trial Act for trial preparation. And then, instead of what we have here in the record, the U.S. attorney says, Your Honor, that's correct. We had this colloquy, wasn't in the record, and we all agreed we couldn't be ready on time when we needed this time. And defense counsel stands up and says, yeah, that's right, Your Honor. You know, we didn't enter it in the record at that time, but we had that discussion at the bench, and it just must not have made it into the record. So we agree that we needed this extra time for trial preparation. And so that's entered here in the motion, that's in the motion to dismiss hearing, and the judge rules on it before he enters the order on the motion to dismiss. Is that sufficient?
no, Your Honor. I'm sorry, Your Honor. I
I thought it was sufficient as long as the judge got it on the record before, and there was something in the record by the time he ruled on the motion to dismiss. I thought that was the case law.
the case law says that,
Now, you can certainly argue that didn't happen in this
and that
case.
didn't happen in this case, and that's why I'm standing in some sorts of confusion. Because what I wanted, I have very limited time, so what I want to tell you is why the finding, the court does not reflect a contemporaneous finding in July that there was a need for additional time.
My question goes to that because it takes off where Judge Harris left off, which is even though the July 22nd and the November orders may have been insufficient, if the record is made sufficient by the time the district court judge rules on the motion to dismiss, my understanding is under the Speedy Trial Act, that's good enough.
Zedner says if the record reflects that there was a finding, at least in the judge's mind, even if it wasn't expressed out loud, that was contemporaneous, that's sufficient. And I believe that's what what you're getting to, Judge Agee.
Right, but your argument here is that didn't happen.
It didn't happen, and I'll just do a double-barreled explanation about why those findings weren't adequate and why there was no record support for a finding on the 7th of July that the counsel needed more time. The judge only asked about, do you have a trial date for me? No, I don't have a trial date for you. We'll get back to you. Nobody said, Judge, even though 11 months has passed already to this time, we're not ready for trial. Nobody said, even though we have 70 more days before the Speedy Trial Act period ends, we're going to need more time than that. Nobody said that, and there's no reason to believe that's true. It's not a complex case. The emails that ensued after that point between the case manager and the attorneys referred only to trial dates. When are you available? I'm available on these days. Nobody said, you know, I just need more time to look at discovery. I need more time to find witnesses and interview. There was no reference to trial preparation. It was all, these are when I have trials, and when do you have trials? And let's make sure our schedules match and mesh, and it's convenient. And so the only reason that can be gleaned from the record for that delay is the convenience of counsel and the judges in slotting the trial around their other trial commitments. And it's not a basis that works. The United States versus Henry establishes that the convenience of the parties, of the attorneys, is not enough. They said...
Counsel, I don't even see how that question is presented here. If the court, in denying the motion to dismiss, had said, I made an ends of justice finding based on the convenience of the parties, then we could have that debate. But the judge didn't even say that. The judge said it's because defense counsel in particular needed time to prepare. And so if there's no basis for that in the record, aren't we kind of done here?
Absolutely, Your Honor. The only reason I'm talking about that is to establish that nobody did say that it was for trial preparation, so absolutely, Your Honor. So on those bases, the judge erred in denying the motion to dismiss. And
Is it possible, I probably shouldn't ask you to speculate. And if you're not comfortable speculating, and if this is an inappropriate question, I withdraw it. But I am actually trying to figure out what on earth happened here. And it did occur to me, before the arraignment, there were those delays, and those were because defense counsel needed time to.
yes, Your Honor.
So I just wonder if maybe, wires got crossed a little bit.
You know,
It doesn't matter.
and I just want to say, until we get to July 7, everything is on track. A formal motion is filed, a formal order is entered, a formal motion, and so on. We get to 7 and everything falls off the rails. Nothing is done that's contemplated. And I think it's because there's not a trial date, nothing's being continued. They're just saying, what are we going to do? And I had another place I was going with that, but I've just lost that train of thought. So, I know what I wanted to mention. If I might just take 10 seconds to mention that in the findings that the judge made at the May 20 hearing, he referred to having granted an extension for defense counsel to have time to prepare, specifically said defense counsel. And I'm wondering, just as a matter of speculation, whether he was thinking about the later continuance where new counsel had to come in because the original attorney had withdrawn. And at that point, of course, he had to give a continuance for the new attorney to prepare for trial. With that, I will address you on rebuttal. Thank you very much.
Good morning, Your Honors.
Good morning.
May it please the Court. Connor Wynn for the United States. The United States similarly will be addressing today the Speedy Trial Act issue, and to the extent that the Court has any questions, Mr. Velasquez's arguments concerning his conditions of supervised release. Starting with the Speedy Trial Act. As this Court was just discussing with opposing counsel, the District Court's ruling on Mr. Velasquez's motion to dismiss comes down to two continuances. One which was granted on July 22nd, 2019, and another which was granted on November 7th, 2019. And the bottom line question is whether these continuances were procedurally appropriate under the Speedy Trial Act, and whether they were substantively appropriate under the Speedy Trial Act's ends of justice exception. And there's also a question of whether Mr. Velasquez should be stopped from raising any challenges to either of those continuances.
Before you begin your argument, which I do want to hear, I had understood that when the United States opposes a Speedy Trial Act motion, that there had to be approval by, what my husband used to call Main Justice. Is that still the case?
Your Honor, I'm not aware that there has to be approval from Main Justice to oppose a Speedy Trial Act motion. In fact, there was no government response to the motion in this case, and the government was never provided with an opportunity to argue against the motion. Judge Deaver ruled on it without responses from the government.
No, but you're arguing against it right now. That's what I'm asking you. Did you have to get some sort of approval from Main Justice to do that?
No, Your Honor, and to the extent that we would, I work with the criminal appellate section. I am Main Justice in a sense. So
that's what I noticed that.
Yes, Your Honor.
So that would have been, if you said, oh, yes, indeed, and I got this approval, and that's why I'm here. But no. Okay, thank you.
Certainly. So taking each of those continuances one at a time. I'll start with the July 22nd, 2019 continuance. But actually, to fully understand the scope of what was happening at that arraignment, it's important to take a step back and examine the lifespan of the case up until that point in time. After Mr. Velasquez was indicted on the superseding indictment in this case, there were a number of continuances moved for by defense counsel, and they were granted. And they were for a variety of different reasons. They were to discuss potential plea negotiations, to examine discovery, to deal with electronic discovery issues that were pervasive in this case.
But none of those are at issue here, right?
No, they're not, but I think it's important to understand, in particularly, there was another 2 continuances granted for defense counsel's medical issues immediately before the July 22nd arraignment. And those defense counsel's medical issues actually interfered with her ability to consult with her client about this case, and she was on medical leave in June 2019, fully not working, right? I mean, she's on medical leave. She's not engaged in her job as a public defender. And it's with this context in mind that the parties meet before the July 22nd, 2019 arraignment. And we know, based on the government's representations at that arraignment, that the parties discussed in their pre-arraignment conference that the, quote, earliest date they could be ready for trial was December 2019. That's what the prosecutor reported to the district court during that arraignment. And that helps to explain why trial preparation was necessary, the course of proceedings up to this point.
I'm sorry, so at the hearing, they said we can't be ready until December. It was clear that it wasn't just that there were other scheduling conflicts or something else going on. They said we need that much time to prepare.
The specific language that I believe was used, Your Honor, is the earliest we can probably be ready is December. And
it's looking like
I thought the
probably.
judge said that.
No, Your Honor, that was the government representing the joint position of the parties. You can see that in the record here on page JA 96 and 97.
It's looking like probably December is the earliest.
That's correct, and that's a
But
statement.
that doesn't say that's because we need that time to prepare for trial.
Oh, no, to be clear, Your Honor, that wasn't a specifically
No one has
represented.
mentioned trial preparation.
No, the trial preparation need is clear from 2 points. It's from context. First, there has been no continuance up until this point for trial preparation. Everything has concerned issues with discovery or potentially defense counsel's medical leave or plea negotiations. And the second point that kind of bolsters the defense need for trial preparation is that defense counsel has been out on that medical leave for such a significant amount of time at this point, which...
That all sounds plausible now, but where do we find that in the record?
Well, Your Honor, that's in the records in the motions for a continuance that defense counsel filed.
We're looking at
Tell me the page.
time after July 22nd.
Certainly, Your Honor.
What we need is some evidentiary basis that backs up what the district court said, either in the later order or at the motion to dismiss. So if what you just relayed was in the record somewhere, that makes a difference. But if it's not in the record, I don't know that that's something that's really relevant.
So, Your Honor, with regards to the medical leave requests, I would direct the court's attention to pages JA 61 and
But is there something in the record that says defense counsel said she needed this much time for trial preparation?
No, there's no specific statement by defense counsel to that effect. But, Your Honor, it's clear from this court's case law that there doesn't necessarily have to be such an explicit statement. The district court is aware of the context of a case and its lifespan. So if it's apparent from the record and from sort of the events that have come before that such trial preparation is necessary, the district court can make an ends of justice finding on its own based on the needs.
How is it apparent on this record after July 22nd that there needed to be a continuance?
After July 22nd or leading up to that point in time, Your Honor?
After. Because that's what we're looking at. That's the gap period. What tells us after that date that there was a need for the continuance?
It's the government's position that it would be the statement from the government at the arraignment saying that the earliest date for the parties is in December of 2019.
Well, maybe the government lawyer was playing a golf tournament, or who knows what the reason is. That's not in the record.
Certainly, Your Honor. It's not and to be clear, the government's not saying that there's any sort of explicit statement from the government or from defense counsel saying at that arraignment the words trial preparation. What there is, however, is there is from the district court at that hearing a statement to Mr. Velasquez indicating that he will continue to have access to his counsel as he, quote, prepares for trial. So even if the parties didn't make the specific...
Isn't that true in any case?
Well, yes, Your Honor, it's certainly true that a defendant will have access to their counsel as they prepare for trial. But what that quote shows is that trial preparation on behalf of the defense is on the district court's mind. So even if the parties don't make a specific request for trial preparation, a district judge can sua sponte grant an ends of justice continuance on that ground if it believes it's appropriate to ensure a fair and just trial for Mr. Velasquez. And it's the government's position, based on the recent medical leave of his counsel, that that would in fact be necessary. To the extent, Your Honors, that this court believes that one of the attorneys specifically needed to say trial preparation was some sort of explicit statement from the attorneys that that was necessary, that might defeat the ends of justice continuance's substantiveness, right? That would render it at least procedurally invalid. But we think that that this court could nevertheless affirm the non-inclusion of that time on the speedy trial clock under this court's anti-sandbagging principles under United States v. Keith, and the way that it has continued to apply those principles in recent years. Essentially, that establishes that if there were grounds that would have justified an ends of justice continuance, and Mr. Velasquez's counsel consented to the continuance that ended up occurring, he's not allowed to assert either before the district court on appeal that those days should have been included in the speedy trial clock. And that
so I read Zedner as setting out a slightly different standard than what we said in Keith. I thought Zedner said, you know, basically defense counsel can't waive this, so we cannot say you're stopped because you consented. We need something much more than consent, and it actually has to be the defense counsel basically persuaded the district court that the ends of justice exception was met. That's what would have stopped you. And I don't see how we can find that here when the defense counsel didn't even say anything at the hearing.
So 2 points on that, Your Honor. First, I do acknowledge Zedner came after United States v. Keith, but this court has, at least in its unpublished opinions, which the government recognizes are not binding, continued to apply United States v. Keith's anti-sandbagging
If the Supreme
principle.
Court has a different view, maybe we were in error.
Or maybe it didn't make a difference in those cases. But if there were space between Keith and Zedner, I'm not sure there is, but if there were, and it were implicated in this case, like obviously we have to follow Zedner.
Certainly, if this court thought Zedner had somehow abrogated Keith on those grounds, then Zedner would control. There's no question there.
Do you think you can meet the Zedner standard here? Is it possible to say that defense counsel, in this case, persuaded the district court that the ends of justice exception was met?
I do think that it is. I think that the representations that happened at the July 22nd, 2019 hearing.
Defense counsel literally didn't say anything.
Well, almost correct, Your Honor. I would amend that statement with one clarification. The district court asked defense counsel if she had anything to add to the government's representations, and she did say no, nothing else. So in that sense, you know, if defense counsel had an objection to the truthfulness or accuracy of what the government had said, she would have been obligated as an ethical matter to respond, and she had nothing to say. So essentially, the government would say that she joined the government's representations onto their conversations leading up to that time.
I think we could say, or one could say on this record, the government persuaded the district court the ends of justice exception is met here because the government said it looks like December is the earliest.
I think the way that I would characterize it is that the government represented the joint position of the parties based on their pre-arraignment conference and was reporting that position to the district court. The government gave that position. The defense had no corrections or amendments to the position, and that's what the district court was operating off of.
Right, but is any part of the government's, I'm assuming now, yes, the defense and the government jointly offered this representation that looks like December is the earliest. I am having trouble figuring out how that is an argument to the district court that the ends of justice exception is met here. It sounds to me like they're just saying we're busy till December.
Your Honor, I don't have anything to add on that point beyond kind of what I have said as to the context and justifications for the substantive validity of that continuance at this point. If the court has any questions about the November 7th, 2019 continuance, I'm happy to address those. I think the arguments in many respects echo this, but the main difference is that there is a series of emails between the parties and the district court's court clerk communicating principally trying to set a trial date. I think this, unlike the July 22nd continuance, implicates government's continuity of counsel, which is a valid substantive reason for an ends of justice continuance. Specifically, the government is discussing its criminal trial schedule, and it's important to realize that there was only one government prosecutor on the case at the time. So to the extent there are other criminal trials that have to be attended to, that impacts the government's ability to participate, obviously, in this criminal trial. That's all the government has to address specifically on the Speedy Trial Act issue, with one final caveat. Obviously, the district court did put its findings into the record at the May 20th ruling on the motion to dismiss. That's enough to satisfy the procedural constraints that Zedner imposes, we would suggest, with regards to ends of justice findings. So we think the real question here, as we've been discussing, is whether the continuances were substantively justified and whether Keith's anti-sandbagging principle should have stopped Mr. Velasquez.
As I read it, all the district court said at the May 20th was, I excluded the time under the Speedy Trial Act for trial preparation, period. There's nothing else that says, because that's what the parties told me, or go back in the record and you can see it at such and such a place. I mean, that's just a statement. And there has to be, wouldn't you agree, there has to be something in the record that verifies that that's accurate?
So, Judge Hadji, we think that's sufficient to satisfy. I want to distinguish here between the procedural and the substantive requirements of the Speedy Trial Act. We think that's enough to satisfy the procedural requirements with regards to an ends of justice exception. It explained the district court's reasoning for its ends of justice finding. What your question is getting at is whether there was a substantive basis in the record supporting that finding. And on that, it's to what the government has already said. I don't think that the district court's ruling provides greater insight into the substantive reasons for the ruling.
Maybe this is just semantics, but now I'm just a little bit confused. I thought part of the procedural requirement of the Speedy Trial Act is that there be a contemporaneous ends of justice finding at the time the continuance is granted. And so maybe we're talking about the same thing. Like, I agree with, I do believe that the district court, this goes back to Judge Agee's question, the finding has to be made at the time the continuance is granted. It has to be put on the record by the time the motion to dismiss is ruled on. So the district court got something on the record on time. That procedural requirement was met, but don't we still have the procedural question of whether was there a contemporaneous finding made at that arraignment? Or are you calling that substantive?
I think I would call that substantive, okay. Your Honor. There has to be a contemporaneous balancing based on permissible ends of justice factors, and that's what I would describe as the substantive requirements of that exception. The procedural requirement is just, is it actually articulated at some point in the record what the district court believes it did?
Is Mr. Velasquez in jail now?
Yes, Your Honor, he is. He is serving a 264-month sentence at this point in time.
And if we should conclude that there has been a denial of the Speedy Trial Act, what would happen then?
So the remedy in this case, Your Honor, it's a little bit complicated because Mr. Velasquez pled to 3 counts, counts 1, 3, and 4 at the arraignment. Because he pled guilty to those counts, those convictions will remain intact even if he prevails on the speedy trial issue here. So if he prevails on the speedy trial issue, the appropriate remedy for this court would be to vacate the 2 convictions he went to trial on, which would be counts 2 and 5, and then remand to the district court to determine in the first instance whether it should dismiss those counts with prejudice or without prejudice and allow the government to retry him on those 2 counts alone.
Does this have any real-world consequences when you look at the sentencing guide?
The sentencing guidelines? Potentially. The methamphetamine charges that he faced were, those drug quantities are more significant.
So he gets a resentencing in any event,
right?
That's correct. So to be clear, in vacating counts 2 and 5, this court would also need to vacate his sentence on all 5 counts under the sentencing packaging doctrine. And then the government, if the charges are dismissed with prejudice, then sentencing would proceed on the 3 cocaine-related counts that remain. If it's dismissed without prejudice, the government will have the opportunity to re-indict and retry if it wishes. I do think at sentencing on the cocaine counts, it seems likely that the methamphetamine conduct might come in as relevant conduct potentially, and query how that's going to affect the sentencing on resentencing if there is one. But that would be, so yes, the appropriate remedy would be to vacate the convictions on counts 2 and 5. I think that hashes the Speedy Trial Act issue pretty well. If the court has any questions on the conditions of supervised release, the government would be happy to talk about it. One thing it would note is we submitted a Rule 28J letter regarding this court's decision in United States v. Elbaz. The government is aware that there has been a request for a response to the petition for rehearing en banc in that case, and the government filed that response yesterday. The government doesn't believe that the standard of review that applies to the 3 supervised release claims here is dispositive. We think it's possible and that this court should affirm on the supervised release issues no matter the standard of review. But if this court disagrees, it may be necessary to hold the case for Elbaz, depending on how it thinks the standard of review would interact with those 3 claims. As to the merits of each of those claims, I'll tick through them fairly quickly. First, there's the question of whether the conditions of supervised release listed in the written judgment sufficiently match the conditions of release pronounced at the oral sentence. Here, this case is a little bit different from United States versus Rogers because the district court specifically said it was imposing, quote, standard conditions. As Mr. Velasquez acknowledges in both of his briefs, instead his claim here is whether or not the district court clearly incorporated certain conditions of release contained in the Eastern District of North Carolina's standing order. So that's a slightly different type of claim. Elbaz suggests that that would be reviewed for plain error. Either way, when there is ambiguity into exactly what sort of standard conditions have been imposed, United States versus Rogers teaches that we can look to the written judgment to clear up that ambiguity here.
It obviously would be better, right, for the district court to take the time to say the 5 extra words of standard conditions in the district order forwards. I mean, it must have, Elbaz itself says if you just say standard conditions, the natural inference is the guidelines.
Your Honor, more clarity is never a bad thing from the government's point of view, but we think that whatever ambiguity did linger in that phrase, standard conditions, can be clarified by the written judgment, as this court indicated in Rogers. The judicial delegation and procedural reasonableness claim as to the explanation, 14 of the conditions here were appropriate according to the sentencing guidelines themselves. The first 13 conditions are recommended in every criminal case. The 14th, when there's an order of forfeiture, that leaves the 15th condition. And whether or not there's a procedurally valid reason, self-evident from the record here, to limit Mr. Velasquez's access to lines of credit or to incurring future credit charges. The government would submit there was in this particular case on the record because of Mr. Velasquez's drug dealing activity.
Well, but so, I don't want to take you too far over your time, but.
As long as you want, Your Honor.
But the government's position is that it's self-evident that he can't use a credit card because he made money from his crimes?
Well, it's the lines of credit specifically, and it's not the government's position that anytime a defendant makes money or anytime there's a case involving drug dealing, such a condition is necessarily going to be appropriate. But here there's record evidence explaining how Mr. Velasquez was something more than an average drug dealer. Specifically, there was a premises enhancement applied because he owned multiple residences which he used for his drug dealing. There's also evidence in the record that he regularly changed vehicles, buying and selling cars. These are the sort of activities that require lines of credit, and it's clear that both the vehicles and the residences were being used to facilitate a pretty significant drug trafficking scheme.
I'm not saying it couldn't be justified in this case, but self-evident seems like a lot. But you think it was so we can infer from this record, obviously the district court was thinking he has a lot of houses, so.
I think that's particularly plausible here because the district court found the premises enhancement valid, and it was clear during the district court's colloquy on that point. It wasn't clear if Mr. Velasquez owned or rented the home, but it was one of several homes. You can see the district court's discussion on this at JA 680 to 684. And then if you want some of the trial testimony relating to the multiple residences he owned, that's at 442 to 443. If the panel has no further questions, the government is happy to rest at this point.
Thank you.
Thank you, Your Honors.
Ms. Hayes, I think you have a little bit of rebuttal.
Excuse me, ma'am?
I think you have a little bit of rebuttal.
A little bit. First, I want to say the history regarding the ends of justice delay. the history of a prior continuance has absolutely no bearing on whether the parties needed additional preparation time as of July 22. The defense attorney needed 30 more days to prepare for the arraignment, which in the Eastern District of North Carolina anticipates trial as well. They are closely paired in the Eastern District. She said she needed 30 days. The court gave her 30 days. That was resolved. She never suggested that she needed another minute for trial preparation that wasn't available to her. She certainly never suggested that she needed more than 70 days that remained on the speedy trial clock to be ready for that trial to commence. So that history has no bearing on the delays that are at issue in this case. I did want to mention on the remedy in terms of resentencing. It's significant that it's counts 1 and 4 that went to trial in this case. They related to methamphetamine. That has a long, the statutory maximum sentence is very long for that. On the counts to which Mr. Velasquez pleaded guilty, the maximum statutory sentence is 20 years. He got 264 months. That's 2 years beyond what a cocaine conviction would warrant. Of course, they could be run consecutively, but it's very unlikely and unusual that sentences on drug counts are run consecutively. Back to the need for trial preparation. There are both procedural and substantive problems with relying on the need for trial preparation. As Your Honor noted, there has to be a contemporaneous finding, and there simply is no hint in the record, and that's a procedural requirement. It's a strict requirement. The court's, Zedner and this court's opinions are clear. There are strict requirements on ends of justice requirements on the procedural grounds. And Zedner specifies there has to be strict procedural requirements because the bases can be so flexible. And so one counteracts the other. The procedural requirements counteract the flexibility in the substantive bases that might be presented. So the court has to be strict about the procedural requirements. And also, as has been discussed, substantively, their record just provides no basis for finding that anybody asked for time for trial preparation. Continuity of counsel has been suggested by counsel here as a reason why a continuance was needed, or a delay. I'm sorry, it's not a continuance, why a delay was needed. The court did not make any finding. The court never said the words continuity of counsel. That is not a basis for the court's findings, and I would submit that's not a basis that can be gleaned from the record in any event. If he had made the finding, it wouldn't be supported. Also, counsel suggests that the court could look at the parties and say, you know, I think you're going to need more time, so even if you don't ask for it, I'm going to give it to you. The Speedy Trial Act does not provide for giving gifts of continuances. The Speedy Trial Act requires that the parties establish that they need time, not that it would be nice if the judge would provide that gift because he's a sensitive, caring individual. Estoppel. Of course, the defense attorney did not persuade the judge to give a delay. There is no indication in the record that on July 22, anyone was thinking about delays, Speedy Trial Act, the fact that they were asking for something unusual. What do you think, counsel? Oh, well, and the court has quoted. It's so clear. And, well, I'm not going to have a chance to address my...
I want to see if we're reading Zedner the same way. As I read Zedner,
Sure.
It wouldn't be enough to stop a defendant from raising his Speedy Trial Act claim, even if his lawyer had persuaded the judge to give an extension. It's that the lawyer would have had to persuade the judge that an extension was warranted under the Speedy Trial Act, that there was... As I read Zedner, you'd actually have to say something like, look, continuity of counsel is at issue here, and then turn around and say, actually, there's no continuity of counsel issue.
Absolutely, Your Honor. And in fact, even Keith requires that. And I will just say very briefly, with respect to the estoppel issue, Zedner says no prospective waivers of speedy trial rights. This is the functional equivalent in this case, where there's an unguided, untethered to anything agreement of unknown duration. That's a waiver that's precluded by Zedner. And Finally, I'll just say with respect to the supervisory, please read my response to the Rule 28J letter, because the standard is de novo review. The issue was whether there's conformity between the pronouncement and the judgment, and there wasn't. So the standard does not apply to the conformity argument. That being the case, I would ask the court to vacate the judgment, remand to the district court with instructions to dismiss the indictment on speedy trial grounds, and alternatively to vacate the sentence based on the nonconformity of the judgment to the pronounced sentence. Thank you, Your Honors.
We will go directly to our last. Okay, I'm sorry. We'll take a very short break. We're happy to hear argument in Tomerman versus Conway. No, I'm sorry, those are the lawyers. Machado versus Garland.
Your Honor, I just had a mild heart attack. I was in the wrong room.
I am so sorry. Just about had a heart attack.
Good morning, Your Honors. Good morning. And may it please the court. My name is Daniel Tolman, and I represent the petitioner, Odalis Chicas Machado, in this case. On appeal, the petitioner raises three issues for review by this court. The first is whether the Board of Appeals incorrectly affirmed the immigration judge's rejection of her proposed particular social groups, which were those who refused to comply with the orders of Salvadoran gangs for religious or moral reasons, and Salvadorans who file police reports against the gangs. The second issue raised is whether the board incorrectly affirmed the immigration judge's finding that the petitioner did not establish a nexus between the persecution she feared and her religion. And the final issue is whether the board incorrectly affirmed the immigration judge's finding that the persecution the petitioner fears would not be with the consent or acquiescence of the government of El Salvador. I'd like to begin with the first issue, which revolves around the issues of particularity and social distinction.
Do you regard the first and second issues as discrete?
I do, Your Honor, because the first issue, I think, I'm happy to address them in whatever way the court would like, but I think the first issue revolves around the parts of what makes a particular social group.
Right.
Group 1 was rejected on particularity. Group 2 was rejected on social distinction. And the second issue, I think, revolves more around solely the issue of nexus, which is aside. Once you establish that a particular social group exists, or a protected trait such as religion, political opinion, race, nationality, then you have to establish the nexus. You have to show that that is one central reason.
Right, but what I was asking you, could a court reject your nexus arguments and still find with you on your second argument?
Well, Your Honor, the nexus, I'm sorry, I don't follow.
Well, I thought your first argument, there was two social groups, right?
Yes.
And if the district court, if this court should conclude that those aren't valid, could it still find with you in your second argument?
Yes, and that's the nexus issue. So to find,
see.
yes,
Okay.
that's why I was confused. I'm sorry, Your Honor.
Well, I was confusing you, so.
The first group was rejected on particularity grounds.
Can I ask you, I'm sorry.
course. No, no,
I
no.
have a question about the relationship between those two claims. If hypothetically, the court agreed with you on your nexus claim, would it be necessary to reach the other, whether there's an alternative? Would you, I'm trying to figure out if you were to prevail on nexus to religion, does it matter whether there are also alternative grounds, where alternative particular social groups where you might be able to show a nexus?
Well, Your Honor, it could, and the reason is that the remedy in that case, it would be a remand to the board to reconsider that issue, applying the correct standard for nexus between the religion and...
But why would you do that if you had already made the conclusion with respect to the second argument?
Well,
Sorry.
that's what I'm saying, that the case would be remanded back to the board.
Well, what if somebody agreed that the record compels a finding of nexus to the protected ground of religion? Then would it matter whether there were also alternative particular social groups at issue?
I suppose that it would matter just to avoid, and let me just preface this by saying.
Well, but you're going to have a nexus regardless.
Correct. So,
If you have a particular social group, you have to have a nexus to that. If
right.
you have religion or race, there has to be a nexus between whatever happened and those factors. You have to have a nexus either way.
Correct. But I don't think that's the reason that it matters right now. I think the reason it matters right now is that the petitioner sought asylum, among other things. And asylum is a discretionary form of relief. The agency didn't really reach the issue of whether she merited it in the exercise of discretion. So it would have to go back to the agency anyway, and if it's going back to the
Here's
agency...
my question,
Yeah.
and then I will leave this alone.
I'm sorry, Your Honor.
This is all hypothetical.
Yes.
If there were a decision from this court sending this case back to the BIA on the asylum claim and saying this record compels the conclusion that whatever actions were taken against your client, one central reason why they were taken against her and not someone else is religion. We have satisfied nexus to a particular social group. Would it in some way be advantageous to your client if also that decision from this court said, and also, by the way, there are two other particular social groups that you ought to look at and see whether there's a nexus to them? Does it matter how many different ways you've shown nexus, or is one sufficient?
Thank you for clarifying, Your Honor. In that hypothetical scenario, I think it would not matter because then the remand order would say, now just figure out discretion and make a decision. So eligibility has been
Well,
established.
you still have to figure out, was the conduct that was directed at your client, did it rise to the level of persecution? Was the government unable or unwilling to control it? But the nexus to a particular social group would be resolved.
Your Honor, if persecution still needed to be established on remand, then I think the particular social groups would matter because different conduct is sometimes ascribable to
Gotcha.
different
Okay.
reasons. So returning to the first group, which was those who refused to comply with the orders of Salvadoran gangs for religious or moral reasons. The board found that that group was not sufficiently particular, that it was amorphous. What their actual language was is that it could encompass a large and diverse group of El Salvadorans. And that could be taken a couple of ways. And I think it's interesting that this arises in the context of particularity because the language that the board, basically the language that is used to define a group is crucial. And if you have too many words, you fail on one ground. If you have too few, you fail on another. So you're jumping from one foot to the other. So I think it's interesting that the board's language could encompass a large and diverse group of El Salvadorans. With regard to particularity, can refer to various things. I think what they're getting at is what this court talked about in Herrera-Martinez earlier this year. As far as the words that the court used were breadth, I think, which is a little more specific. But when I read could encompass a large and diverse group of El Salvadorans, I think, well, so could homosexuals. But that would definitely be a particularized group that would encompass a large and diverse group of El Salvadorans. So the words that the board uses make it difficult to tell whether they're actually focusing on particularity or if they're focusing on something else. So that's something that needs to be clarified, and they need to better explain their reasoning. We use the example, and what the IJ, the immigration judge, and the board went back to a lot was that essentially the reasons, the religious or moral reasons, that's where the ambiguity comes in. And as we argue in our brief, even if 99% of the population of El Salvador opposes gangs, some might do it because they're teenagers who are afraid to get in trouble with their parents. Some might do it because it's not going to let them get into college. Some might do it because they don't want to get caught by the police. But then a subset of the population will do it for moral or religious reasons, whatever that religion is, whatever that morality is. But there's something internal about them that drives their opposition, or not their opposition, because in this case there's concrete action. There's a refusal to cooperate. There's an approach and a refusal. So we've got the group of people who have been approached and refused to cooperate, and then we have the reason why specifically. And I think that that's clear enough to meet the particularity standard.
Okay, now maybe you can address your second.
Yes, thank you, Your Honor. Salvadorans who file police reports against the gangs. What I think that this, and the board.
That is 1A, one.
Yes.
I was interested in 2. I mean, you have 5 minutes, so you can use.
Yes, I'm sorry, Your Honor. So for that group, essentially social distinction is the issue. I think that it's pretty well developed in the brief that what level of publicity is needed for cooperation with the police to become public for purposes of that. And again, we go back to the issue of the wording is so crucial. In Herrera-Martinez, there was a discussion about that as well. And even in respondent's brief, it says that essentially the cooperation, if it had been witnesses for the police or something like that, that might have been sufficient. And this has come up before the court as well. But there's always been this element of that having to be public. And it's the added words that somehow affect the cognizability of the group. In HLSA, essentially, it focuses on that aspect. What social distinction is supposed to be is how outwardly you're perceived, which is almost like ocular visibility. And that's not obviously what social distinction is supposed to be. The fact that the petitioner's report became known to the gang a couple of days later indicates that it was something public. She was not secretly meeting with an officer by herself. She was not snuck into the station in a squad car. She went in, I believe it was December 4th, and then on December 6th, they already knew about it. So unfortunately, the record does not tell us whether it was because she was telling people she went to the police or if it was because, as she claimed, the gang was following her and they saw it. But presumably, she went into the station through the front door, and if the gang is watching her, that's a public act. Walking into the police station in El Salvador is a public act. Anybody can see you do it, and there's only so many reasons somebody would. So she went in, she filed a report, and I think that that meets social distinction. So moving on to the issue of religion and nexus, the petitioner suffered various forms of persecution. And at one point in the transcript, during cross-examination, the government attorney makes a lot of the fact that during the credible fear interview summary does not reflect what petitioner testified during court, that she was harassed on her way to and from church. That's what brings her to the attention of the gang.
But why was she harassed?
Well, according to her, it was because she was a Christian, because she was an evangelical. She was out there preaching.
I thought the record showed that because the location of the church gave whoever was there an eye view of where the police cars went, and they wanted somebody who could tell them when the police were out and about.
I don't believe it was, well, that has something to do with why they attempted to recruit her. So it gets a little complicated because it's a mixed motive case, clearly.
I thought that they said that no one would suspect her because she goes back and forth to the church because she's religious.
Correct.
So it was not just her location, but her connection with the church.
Correct. So that is one thing. But again, this is what makes her useful to them.
Right.
But she also was very clear throughout the record there's no dispute that she was told, we don't like you because you are evangelical. We don't like that you are out there telling young people not to do crimes. So there are
also testified that they didn't care whether or not she was Christian.
And that's, I'm glad Your Honor brought that up because that came up in a specific context. And if nothing else, there's a reason to remand for that to be clarified. Once again, we go back to could encompass a large and diverse group, could be taken different ways. When I read the transcript, it's clear to me that what she's talking about is essentially they're saying, we're not going to not harm you because you're Christian. We don't care that you're Christian. We're still going to harm you. Not that that's not a reason that they're harming her. So it's almost as if they're taunting her faith. It's almost as one of those, where is your Messiah now type declarations. So that could be taken differently. And I think that the judge and the board took it the other way. They took it to mean that, the persecutor is never going to just outright tell you,
I don't even see how you could take it two ways.
No.
What she says is, they told me it didn't matter that I was Christian. They could do whatever they wanted to do with me anyway. I don't actually see any way to take that the way the board took it.
well, Your Honor, exactly. The anyway at the end is what seals it for me. It's like, we don't care that you're Christian. We're going to hurt you anyway. So it's not,
Well, you were suggesting at one point we had to send it back to the board. Well, if we think that the board misinterpreted, we don't send it back.
I understand, Your Honor.
We don't send it back for them to make new findings if it's, okay.
Yeah, I apologize, Your Honor. I guess I just got caught in the moment there. I wasn't expecting to be asked about the remand scenario. But in any event, just to wrap up that issue, as I was saying, persecutors don't generally tell their victims, this is and this is not the reason why we're doing it. It's all drawn from context. And the context in this case, the record shows that religion was one central reason why she was in this situation. So was her refusal to cooperate. There's a mixed motive, but one central reason was religion, and that is sufficient under this court's precedent. Thank you very much. I see my time is expiring.
Good morning. May it please the court. My name is Kevin Conway. I'm appearing for the government. I don't know if the court wants to follow in the same order that the three issues, or would that be less confusing? It doesn't matter to the court.
Do whatever way you want.
Thank you, Your Honor. The government contends that substantial evidence supports the finding that Ms. Chicas Machado was not persecuted on account of her religion. A persecutor has to prove that religion was one central reason for her persecution, and consequently, in this case, Ms. Chicas Machado had to show that her religion was more than an incidental, tangential, or superficial or subordinate reason for the persecution. Yes, ma'am.
Let me just sort of go right to what I think is the hard question here. So the BIA's own opinion says, here's why they persecuted her. They told her they wanted her assistance because no one would suspect she would be working with the gang based on her conduct with the church. I mean, isn't the BIA itself saying they picked her because her church membership and her religion would make her seem non-suspicious?
Well, what the board was saying, I believe, was that they chose her because no one would suspect her of helping the gangs.
Right.
I don't think.
Because of her religion.
Well, because she had an association with the church, but not because of necessarily of her religion. They weren't trying to overcome or change her or.
That's not the question. Like in our family persecution cases, you don't ask, are they trying to like make you renounce your family and join a different one? You just say, are they coming after you because of who you are related to? And even the board says they're coming after her because of her religion and her church affiliation.
I guess I see a distinction between her religion and her beliefs as far as that goes, and what the gangs wanted from her. And it was not anything to do with her religion or that she was Christian.
We can reconcile that with our nexus cases, which all are really clear about the fact that you don't have to hate the family, you don't have to hate the group. You may be doing this to recruit gang members, you may be doing it for money, but if the reason this person is the person in your crosshairs is some protected ground, that's enough to show nexus.
Well, my understanding is that, my understanding of the board's decision is that the gangs were interested in her for what they could provide to her, not because of her religion. Yes, she could have been any religion. She could have been it might have been any reason. She might have been working in a shop that overlooked the same area where.
No, that I don't think is true, because they did think that, or she said, and we don't have any evidence to the contrary, that they thought she wouldn't be suspected too.
Also, that's what the board said. They didn't
Yes.
say because of the location. The board itself says no one would suspect she would be working with the gang based on her conduct with the church. So I just don't see how we can reconcile that part of the board's decision with our increasingly long line of nexus cases.
Well, I understand the board, the panel's position, but that's.
I should phrase it as a question. Is there a way we can reconcile it with this?
Well, that's what in my mind, yes, but you seem to disagree with why.
So the only way you think I guess you haven't actually, how would we reconcile that with, say, Hernandez Alvarez? Am I getting the name wrong? The one about the woman who is targeted by the gang because they want to recruit her son for gang membership. They don't hate her, they don't hate her family, they just want to recruit the son, but we hold the reason they went after her and not somebody else is because of her relationship to her son, and that's enough to show nexus. Is there a way we can reconcile what the board said here with a case like that?
I think the only way you can reconcile that is to look at the gang's ends and means. The only reason that they wanted her had nothing to do with her religion other than the fact that she would not be suspicious, there would be no suspicion on her because of her position. And that it had nothing to do with her religious beliefs, so to speak. I don't know if that is enough of a distinction for the court to make a decision on. With regard to the particular social groups, starting with those who refuse to comply with the orders of Salvadoran gangs for religious or moral reasons, the board found that if the PSG failed on particularity grounds because of the phrasing for moral or religious reasons was an amorphous characteristic I'm saying that this court has found that opposition to or resistance to gangs is an amorphous characteristic providing neither an adequate benchmark for determining group membership nor embodying a concrete trait that would readily identify a person as possessing such a characteristic. In this case, the board found that what constitutes a religious or moral reason is just that. It's overbroad and subjective in and of itself. I know that the board, even though, the petitioner argues that the board misconstrued the standard to refer to the size and composition of the group instead of whether its members were sufficiently identified. Yes, the board did reference the size of the group, but what we're more concerned about were the imprecise parameters of the group, meaning the religious for religious or moral reasons, because one can't tell what someone's religious or moral reasons are.
So just so I make sure I understand the government's position, you agree that the size of the group is not the right question, but your argument would be that's not what the board was really relying on here.
Right, it's not the only thing to look at. I know that there is case law out there that says this, the size is not necessarily an indication for particularity, but the board said that in conjunction with other reasons for their finding. And the petitioner in their brief cited to the illustration of the Catholics that was in Amaya v. Rosen. In that case, they had posited the Catholics was a particular social group, and that Catholics may vary widely in length of time they have been in the faith, their criminal involvement, which may have an impact on nexus, but not on particularity. Well, that example in this case is not applicable because a social group such as Catholics, without any other parameters, is clear who is in the group and who is not. In this case, if the purported social group had identified only those who refused to comply with the order of Salvadoran gangs, perhaps that would be enough to figure out who was in the gang and who was out. But now we have, as counsel has said, 99% of the population of El Salvador may oppose the gangs. But in this case, they have, put on extra parameters, extra wording that makes it more difficult to find particularity in this case. As we argued in our brief, the terms for religious or moral reasons are not self-limiting and are more in line with the terms of this court has found to be amorphous, such as wealth and opposition to gangs. Americanization, criminal history, those are all amorphous characteristics that we think that these, for moral and religious reasons, fall under that same category. With regard to Salvadorans who file police reports against gangs, which the board found not cognizable because of it lacks social distinction, the board noted that the gangs harm anyone they perceive to interfere with their criminal enterprise, that persons who file police reports are not in a substantially different position than anyone else who is perceived to be a threat to the gang. And there is no indication.
Excuse me, is there any evidence in this record that her filing of police reports against the gangs was well known?
There is not. The only, there's no.
Did she testify about that?
She testified that she filed a police report, but there was no testimony as to whether she told any friends or relatives or anybody in the church that she had done so.
Or that the abusers knew that? Did they know that?
The gangs found out apparently 2 days later because they came and threatened her on 2 days after she filed the report. There is no indication even in the record as to how she presented that report to the police. Counsel has posited that she walked in the front door, a very public act, but there's nothing in the record that indicates that's what actually happened.
Well, but if they knew about it, I mean, maybe the group would be people who file reports against the gangs which the gangs know about. That's a narrower group than people that file police reports about the gangs, right?
Right, but we don't, I mean, that wasn't presented to the immigration judge or to the board as a social group in this case. We don't know, then this court has
Yes.
has ruled on the public nature of involvement with the police, such as testifying at trial, participating in a lineup, things of that nature. This is not that. Well, actually,
No, but we suggested that when you report and no one knows about it, that can't do anything. I don't know that we've ever reached the question of whether you report and then your abuser knows about the report, whether that's a different group. You understand what I'm saying?
Yes, I do, and that it would be a different group, but that's not a group that was pled in this case.
Okay.
As to Your Honor's point, the evidence of record does not support the inference that Ms. Chicas Machado's friends, family, and society in general were aware that she had filed a report, or that people who file police reports against gangs necessarily are cognizable as a group because of the public nature of it.
Is there any tension here between, and I guess I could ask your colleague this too, the parties' positions on this police report issue and then what's being argued over on the cat side of things? Because if nobody knows that she filed this police report, except for the police, and then the gang finds out, that does seem to indicate that the police are working with the gang, right? Do you know what I'm saying? If this were a sort of public knowledge, then there wouldn't really be much from which one could infer that the police, in this case, was actually working with the gang. But if, in fact, nobody knows about it, except for the police officer, and then the gang finds out 2 days later, that does sort of lend credence to the argument over on the cat side of things that, at least in this case, someone's acquiescing in what's going on. Do you know what I'm saying?
I understand what you're saying, but there's no evidence in the record that shows how the gang found out. Again,
But if you're right that this is like a purely private thing, nobody knows about it except for her and the police, and then the gang found out, then I guess we actually can infer that it was from the police.
right, but then we're looking at this in the context of social distinction. And at this point, I mean, I suppose on the cat side, we can discuss that then. But the social distinction requires that, how this is viewed in the public, in the society in general, in question, and whether or not this particular social group of people who
So
file
between
police report.
maybe just a few people know and one of them told the gang.
Right, I mean, we don't know how the gang found out, and then I guess the burden is on the petitioner to, to prove their case as to all of the requirements for PSG or to show a particular social group. With regard to the failure to demonstrate eligibility for cap protection, we have the petitioner reported was first threatened on December 4th and reported the threat to the police at some point between the 4th and the 6th. On the 6th, she received a threat from the gangs, and then on the 16th, she had fled the country. There's no evidence to show, I mean, when she filed the police report with the police said that they would look into the matter. There's no evidence that there was any follow-up by the petitioner with the police to see any steps that they had taken. There's no, she says that nothing was done, but she left the country 10 days later, so we don't know from December 6th on, what, if anything, happened with the police's response to her report. So she has, she hasn't shown that there is one that Salvadoran government was unable or unwilling to assist her, or that they had not taken any steps to rectify or to remedy her situation. The board acknowledged, that there's corruption in the Salvadoran government, but also noted that the government taken steps to combat the gangs. There is case law that shows that the national government has attempted to alleviate the gang problems, have been unsuccessful in some respects, perhaps successful in other steps. And for those reasons, we believe that she has failed to show her eligibility for cat protection.
And I do see that you addressed the cat protection in your brief, but I wasn't sure that cat relief was requested by the appellant here.
It was.
Yes?
And I mean, it's
Okay, well,
kind
they
of
can show
intermixed
me where
with.
it is in their brief.
Yeah,
Okay. But you're conceding it was. Fine. Okay.
Yes, it's intermixed with well-founded fear, I think. It's in the later stages of the brief.
Okay, thank you.
So what impact on the claims here does the findings by the IJ have that there was failure to produce evidence on the ability to relocate? How does that factor in?
I don't believe it does because the board did not address that issue in its decision. The board decided the cat issue on other grounds and didn't
I see it.
didn't address the failure to relocate or to attempt to relocate. If there are no other questions, then the government will rest on its brief. Thank you very much.
I see where you made the cat argument.
Thank you, Your Honors. I'm just going to focus on some of the things that were brought up during the government's argument, and I'll work my way backwards. Regarding the cat issue, since we're talking about that right now, yes, it was requested and it was argued, but in this case, it seems pretty, asylum is still obviously the petitioner's primary objective. However, regarding what happened with the police, there may not be evidence that the police did or didn't do something, but what there is evidence of is that something did happen after she went to the police. 2 days later, the gang came back, and according to her, she knew that they knew about it because they told her exactly what was in the report that she filed.
Counsel, I really do have a question, sort of the same question I asked our colleague, but it seems like a slightly more salient issue for you. I mean, you're arguing over on particular social groups that people who file police reports are a distinct social group because everyone knows when people file those reports. If that's true, I don't see how we can infer that it was the police who told the gang that she filed the report.
Correct, Your Honor. However, as I argued during my opening argument, I think that it's the act of filing the report. So, and actually, I'll just jump back to the second part of it because it interrelates. When we're talking about particular social groups and things like social distinction and things like that, and particularity, what we're really talking about isn't the person specifically. That's an issue of showing that you belong in the group. It's more about the definition of the group. So if I tell somebody, anybody, if I tell them, like my cousin filed a police report against organized crime, that's perceived as a segment of society, people who file police reports against organized crime. You can hear about a neighbor, you can watch a movie about it, you can read about this in the paper. It's something that is perceived within society. You don't have to know the person. And it's a different question to say, well, did they actually do it or was it really organized crime? But it's the idea of that group that society recognizes. And that's really what we're getting at with social distinction and particularity. So that's how I reconcile those two things. Our argument is that the way that, even if it was just the police that knew about this, then yes, I mean, it is a pretty strong indication. I agree that, or it would be a strong indication that the police are, in fact, as the petitioner alleged and the country conditions evidence showed that the police are colluding with the gangs, at least at the local level. But at the same time, it doesn't change the fact that she is a member of that subset of society who filed police reports against gangs. So that's how I reconcile the two. The only other thing really is, see, when I work backwards, I lose my train of thought, so I apologize. With regard to the other group, as the government said, that the extra parameters added relating to moral or religious objection, or moral or religious reasons being why the person refuses to cooperate, it is not an excessive number of additional parameters. And in this case, I think that it actually makes the group more particular. Again, we're referring to subsets of society, and I told you earlier various examples of why somebody might oppose the gangs. This further narrows that group. So the addition of those words, and those are not amorphous words. You don't have to know which religion it is. You still know what opposition on religious grounds are. So it isn't the same as youth or wealth, which are purely subjective. Morality and religion are things that are clearly defined to the extent that in this case they add particularity, they don't detract from it.
Before you sit down, you just
Yes,
take
Your
a
Honor.
minute. Back on the cat claim, all the relief that you ask is that we reverse the board's decision and remand for additional proceedings under the correct legal standard. What might that mean?
Sorry, Your Honor, I didn't get to the cat section during my opening argument, and I apologize that I'm over my time. If you'll allow me to respond. Well, in this case, they should evaluate the cat claim, and I guess it shouldn't have been a correct legal standard, perhaps as a poor choice of words, but the fact that measures have been taken, and it's public knowledge about the situation there now since March under the new president, broken truce with the gangs and everything that's happened. And I think that the claim should be evaluated under a correct appreciation of the situation in place and the fact that there is indeed police collusion and acquiescence in what the gangs do. Thank you, Your Honors.
Thank you. You have further questions? No. Thank you very much. We'll ask the clerk to adjourn court.
This honorable court stands adjourned, sine die, God save the United States and this honorable court.